You invested the money in solar. You invested in solar and you were selling money back to the grid, that was gonna go away. It is now not going away, thanks to legislative teams and people like Karen, who, by the way, brought it up, who was the spearhead of the whole. Because there are 2,300, and yes, exactly.
Hey, Bo, it's David.
There are
I'm trying to get on this
2,350
Zoom,
pieces
but we just
of
got it sorted
legislation
out. They
in front
started
of
the meeting
the panel, in front of the legislation now. It's down to
but
about
Karen
half of
just
that
got a
now.
text and like they just got it going. So
Just an
I
incredible
figured
amount of
I didn't have
legislation.
Karen's phone
And by
number,
the
and I
big
thought maybe
beautiful
you could
bill
tell
that
them
just
that
passed, the
the Zoom is
reconciliation
going out
bill,
right
there
now
was
about
one
Berkeley
line
Rent
in the
Control.
bill
There was
that
no
said Donald
sound.
Trump, President of the United States. And some analysts found it.
But it's all squared away. It's working now. So I didn't leave you a message because you said you're out of
critically, government affairs people are super
about
critically
that.
important. So solar bill
All right,
10,
buddy.
you can keep going. You might
Thank you
have
for your
heard
help as
yesterday,
always.
there was a
Bye-bye.
little offhand comment in the White House press conference about eliminating capital gains. Let's not get too excited about that. It was just an offhanded comment. Obviously, this would take legislation, ways and means, everything else, but there was a lot of, oh my God, we're gonna be able to sell a house. And for instance, my 86-year-old mom's got a $2.5 million house in Millbrae she can't sell because the capital gains, 40% on capital gains was.
So lame. The first 10 minutes they have no sound.
Anyway, let's not get too excited about capital
On the
gains.
chat.
Also, Jordan, October 6th, I'll be listening on that one because he's amazing. And then I would encourage you, as you're paying your dues and you're going through, and Karen will bring it up, this the Realtor Action Fund. We can't use O&M funds. We can't use operating capital money for political expenditures. All this stuff that we do with legislators have to be paid by fundraising. And that's you guys. And Bridge is a little bit ahead of the state average, so I don't have to scold you. But RAF is one of the most critical things you can do. And Karen can share lots of information with you. So, all right, that's all I got. I appreciate the panel today. Should be a really interesting day. Thanks, Karen. Appreciate the time.
All right. Thank you, Andrew. You can give this guy a hand. He's like all over up and down the state. And I'd like to it looks like Commissioner Nathan Mizell is here. I'd like to just give him a round of applause for showing up. We've never had a rent board commissioner here at the association. Now, and just one note on something that Andrew said. It wasn't me necessarily. It was actually our former president who got on the phone to me and said, "What's going on with this bill? It looks like it's a point of sale now." And then I got on the phone to CAR, and that's how we got a hold of that one. But anyways, great results because of the CAR team. Thank you, Andrew. Now let's move into today's feature presentation on Berkeley rent regulations, and we have a very interesting set of panelists here before us. First, we have staff from the Berkeley Rent Stabilization Board. We have Matt Brown, General Counsel, Moni Long, Housing Counselor, and then their boss, Executive Director, Deshaun Williams. All right. And then we have from BPOA, which is the Berkeley Property Owners Association, if you didn't know. Executive Director and my friend, Krista Gilbranson, is here. Give her a round of applause. She works hard. And before we get started, a quick disclaimer. This presentation is intended for informational purposes only. Bridge AOR does not provide legal advice, and nothing shared here should be construed as legal counsel. If you have specific questions about your rights or responsibilities under Berkeley rental law, we encourage you to reach out directly to the Rent Board, BPOA, or consult with a qualified attorney who specializes in landlord-tenant law. Now, we are grateful to have our speakers here today, and thank you to all of you for taking the time to learn and engage with them. With that, let's get started. Thanks, folks.
Thank you, Kieran, and thank you, everyone, for your attention today and having us as your guest. I'm going to give you a quick overview of what we're going to cover today. And after we close our presentation, we are also friends with Krista. Krista and I are friends. Krista, I'm giving her a card to see her face. We work together actually quite often. I just wanted to have a misnomer corrected. A lot of people think we don't talk to landlords or property managers, just tenants. Over half of the people that I actually counsel are landlords, property owners, realtors, buyers, and sellers. So this is an important presentation, what realtors, buyers, and sellers need to know in Berkeley. Because I had a buyer who called and didn't know that his 5-unit building is under rent control. And I'm like, what do you mean you didn't know it's under rent control? Oh, did you have a realtor? So I know realtors know this, but sometimes people buy it with an out-of-state person or a friend that told them, and then they got the $30,000 bill for unpaid registration fees from the prior owner and control building that they didn't understand. But he's now squared away, everything's good, but we're here to make those things not happen, and also to give you new information. So we're gonna go through rent control basics. Okay, I'm just gonna go to the next screen. I think we have our little agenda. There we go, thank you. We also have handouts, so some of the things I covered, this is what I always like to say, please hold your questions to the end, because you may have questions, and that's great, but we're gonna hold those to the end so that we get through the entire presentation. But there's a stack of handouts, there are 9 items, but you don't want to look at it right now, because you want to pay attention to all of this. It's having rent control basics, the history of our agency, and the legislation that passed by the voters would be kind of part of what our executive regional coverage of rent control basics outline of history. Also, the status of property units. You all know that there's a difference between fully covered economics and partially covered. A lot of new changes in the law have happened. Evictions and buyouts, we're going to cover that as well. ADUs. What about ADUs? Everybody wants to know about ADUs. We're going to cover that. Measure BB, the law that just passed, we'll cover that, and then additional information. So with that being said, I'm going to start with Sean. It's going to be Sean's going to cover our history, kind of going through the history of rent controls page here. Advancing one, or actually, do you mind advancing first? Oh, never mind, he's got the clicker. All right, never mind. Okay, thanks.
Good afternoon, everyone. Nice to see every faces on. I've been here for about 3.5 years, so I started as if I got here yesterday. Coming from the city of Detroit, working in public housing, affordable housing for about 15 years. So I'm reading my little notes on here because it's still new information to me from my perspective. But we're going to talk about real quickly is the history of the rent board and some of the rent control ordinance. So it was a council adopted temporary stay to react to high rising rent increases and housing instability. And with that temporary, then it was voter adopted in 1980. Again, that is where rent control comes into the city of Berkeley. And it was tumultuous, and I think I was 7. I'm not counting my age, sorry. I was 7, but it was tumultuous. But again, the voters adopted and passed the stabilization eviction for good cause ordinance in 1980. And so through 80 and 85, that is when the Fisher versus Berkeley, which was a landmark case that the California Supreme Court basically upheld most of the provisions in the ordinance, and it established rent control in the ordinance here in the city of Berkeley. So the rent board begins to establish its processes, its operations, and provide provisions for services. But that case, the Fisher versus Berkeley, basically allows rent control ordinance to stand up to judicial scrutiny. And so that is very instrumental to our history. So again, the rent board becomes a formal agency, operations and systems get in place. But what happens for some pain points for property owners and landlords is now they have to register. They have to register their properties. So Costa-Hawkins comes into place in 95. And there were 3 kind of major establishments with Costa-Hawkins that was a little bit contradictory to the rent control ordinance, which means that there was vacancy control, which cities then they couldn't limit to the limit of rents once the unit became vacant. It exempted single family homes and condos, and then it also exempted new construction, right? And so that would be anything February 1, 1995 is considered, which is kind of a weird thing for new construction, right? 1995 at this point. But that is what Costa-Hawkins meant to the rent control ordinance. But in 2020, we passed Measure MM. And again, this entire time, the rent control board is still being operationalized and providing services. But the rent control ordinance is evolving. In 2020, it evolves even more, and it allows registration to those that previously exempted, which would be single family homes. And condos that were renting are now coming into the fold under Measure MM. And that was in 2020. So it, again, the ordinance is evolving in that way. And so that coverage increases the portfolio and the services that the rent board is providing to landlords. And then we continue to evolve. We continue to evolve with Measure B, which was just recent, in 2024. So it was voter adopted in 2024 and implemented in December of 2024. And what that did was expand even more coverage under the ordinance. We now cover government subsidized units, which were previously exempt. There are more registration requirements, and compliance requirements, and we're gonna go into Measure BD in more depth, but again, what you can see is over time is that the rent control ordinance and our services evolve over time, but that is what we are responsible for, that is what we cover. That's just a little bit of a snapshot.
Thank you, Shauna, for the snapshot and for making me feel old. She was in kindergarten when I was in college at UC Berkeley. She was 6 and I was 20.
Can't tell on you told on yourself.
I did tell her. So next, I'm going to cover just a few basics, the 4 pillars of rent control. Rent control, that's the element of what you all know probably is the G&A. That's your annual general adjustment of what you can increase the rent by. So we regulate the rent. We also require registration. That's the second pillar. The third and big one, which we're going to cover 2 key points you'll want to know for your clients. Just cause to evict includes on move and eviction. And also, a lot of people don't know about this, but I want to make sure you do know this. We call it the sabbatical clause. So if you rent out your house for a year, you may live in France for a year, you have to write it in your lease, and we'll go through that, but you don't have to pay a relocation permit. It is one of the specific just causes to evict, is if it's your primary residence, you're renting it, and you move it back in. We'll go over the other just causes too, but, and the fourth and final pillar is security deposit interest. Some cities have this requirement, not just Berkeley, but not all do, and you have to pay the annual interest every year of the security deposit to the tenants. So that's the key important part. And now we pass off to the status of property units, keeping that down our general counsel.
Thank you. Just to place myself in the timeline of 9. Way. I've been working at the rent board for almost 22 years now, so I'm right in the middle of the timeline from when it started to now. You may be wondering why general counsel. The Berkeley Rent Board is a city agency, but is a little bit separate and distinct from most city agencies because we are not under the city manager umbrella, meaning that we are not subject to any authority by the city council. So we have 9 independent elected commissioners, of which Nathan Mizell is one. And that particular elected body advises and essentially controls the board. So
just to the folks online can't hear you, so speaking on the mic.
Oh, sorry about that.
There you go.
Okay, so whereas any sort of complaints or challenges to the law in the city, if you were working for the Health, Housing Services, Planning Department, Department of Public Works, Parks, Rec and Waterfront, whatever it is, would go through city council or maybe city attorney. Here they go through our elected commissioners, which comprises the elected rent board, Sean or me. Okay, that being said, we are now sufficiently oriented. I'm going to go through a few slides regarding what the status of rental units are. Moni and Shauna sort of tease this particular piece, but all rental units fit into one of these 3 categories. Fully covered, and when we think about this, we should take sort of the tenancy, the faces of the tenants off, and think more about the unit itself. In other words, the law travels with the unit and not with the faces. So for fully controlled units, fully covered units, those are all multi-family residences, so duplexes, triplexes, and above, that were built prior to 1980. Okay, and for partially covered, those are all single-family homes that were rented after 1996, so have current tenancies that began after 1996, and all new construction and condominiums. And new construction, of course, for Berkeley, is anything built after 1980. And then there's the exempt properties, which realtors are always very energized by. When I come to these presentations, we've been doing these presentations for many years. And those are ones where there's an owner occupant in certain duplexes, or ones where an owner occupant shares a kitchen or bath with other tenants in the property. Just to further orient you, the registration fees for fully covered units are $344 per unit. For partially covered units are $212 per unit. And then, of course, the grand prize of $0 for exempt units. And as Moni said, and this is something that that we really like to emphasize during our realtor workshops, is that the debt travels with the property. And therefore, if a seller sells a unit that is delinquent on registration fees, the buyer would be responsible for them after the close of purchase. And we do have a compliance unit that does regular work to try and reconcile all bills that are delinquent. Exempt properties, this is the slide you came for. Owner occupied duplexes, which are the golden duplexes, everybody's heard of those. Properties occupied rent free. An owner's cousin lives there, uncle, sister, doesn't charge any rent. Units that are not available for rent. This is what I want to emphasize, because a lot of people have trouble with this. It's if there is a moment in between tenancies, and this happens quite frequently when you're selling properties, where you're selling one of the units being vacant. That does not necessarily mean that that particular unit in that property is not available for rent. It would be not available for rent if the owner decides actively not to rent it. If the unit is being remodeled or being upgraded, kitchen, cabinets, flooring, bathroom, heating system, whatever it may be, and the unit would be offline for a month or 3 months or whatever, during the pendency of those repairs, that is still available for rent. So we just want to make clear that when you are advising your clients about their obligations as it relates to a rent controlled property, that having a unit temporarily offline for repairs does not qualify as non-conforming. However, in the event that the owner lives, for example, next door and no longer wants to rent that unit for the pendency of their term in the property or their occupancy of the property, that is not available. Just wanted to clarify that. Any property owner that shares a unit with their tenants is categorically exempt from rent control, meaning that they would not be covered by any of the 4 pillars that Moni mentioned. No rent control, no registration, no eviction protections for the tenant, and no security deposit interest owed. And then, of course, ADUs, which I know that a lot of you are interested in as well. For any ADU where a tenancy was established after November of 2018, those are similarly exempt from the ordinance, just in the exact same way as golden duplex tenancies will be. Now, the golden duplexes, this is, if you can answer both of these questions as yes, then the property, the rental on the unit, assuming there is one, would be completely exempt. So the first question is, was there a principal owner occupant on December 31st of 1979? And the second question is there currently a principal owner occupant? And that owner occupant would have to be somebody who owns at least 50%. And if you can answer yes to both of those questions, then the other rented unit on the property is completely exempt from rent control. Okay. I'll answer questions about that at the end of the presentation. Now, the fully covered properties, A number of your clients are buying duplexes, triplexes, quads, that are built before 1980. You know, the vast majority of the Berkeley rental housing stock is pre-war. We see a lot of new construction in the Shattuck University corridor in the last 15 years. But for the most part, things that, you know, that a little bit farther this way, all the way over there and down there are all going to be, you know, 1940s and before, for a vast majority of properties. So most properties that are in, you know, the not in the downtown corridor are going to be rent controllable when they're occupied.
You guys don't have to take a picture of every slide. We're actually gonna give you the whole presentation. I meant to tell you all that. Karen will have a copy sent to everyone.
And so what does that mean for fully controlled properties? It means that when a rent is established, you have to wait 2 calendar years in order to be able to incorporate your first adjustment of rent. So every year, the board publishes and what's called the AGA, the Annual General Adjustment, and that is connected to the Consumer Price Index for the Central Bay Area, the Oakland, San Jose, San Francisco, Central Bay Area, which is published by the Bureau of Labor Statistics every month. And so we take an average, rather we take the increase on a year-by-year basis. And 65% of that landlords are entitled to adjust the rents. So most years it's around 2% during that period of hyperinflation, just after COVID in 2022, it was around 4.4%. But for the most part, it's 2% or below. What I mean by you're unable, rather, when you first establish a tenancy, the first rent increase that you're able to issue for that tenancy would be 2 calendar years later. So let's say that somebody moves in this month, in July of 25. You would not be able to, or the landlord would not be able to raise the rent in 26, all the way until January of 27. And then thereafter, every single year in January, we'd be able to raise the rent again on that tenancy. What else does it mean? It means that tenants have eviction protections, and there are 10 enumerated just causes. We'll discuss some of them later in the presentation. And then, as Moni said, there's a security deposit interest that's payable every year. That might sound frightening, but in the last 8-10 years, maybe, it's been less than 1% and sometimes 1/10 of 1%. So 1/10 of 1%, $1 of interest owed for every $1,000 retained as a security deposit. A security deposit is considered last month's rent, a traditional security deposit, damage deposit, any kind of thing that's labeled as a deposit on the lease agreement. The landlord actually holds in fiduciary capacity for all tenants and owes interest on those deposits.
Matt said I could receive.
Yes, please.
On this point, very important. Did you know that if you don't pay that dollar by January 31st, it turns to $100? Regulation 704, I'm here to save you and your clients. So it's an incentive to ensure that the property owner does pay the interest on the security deposit by imposing a one-time 10% of their security deposit. So it's $2,500 security deposit, $250. They can take off their rent without giving you notice per regulation 704.
Thank you. I fully previewed this one in the last slide, so I'm just going to take a moment to have it sink in. This is the 2-year rule that I was talking about, 65% of the CPI. The upshot is that there is no vacancy control in Berkeley. One of the things that cost office did, Shauna mentioned on the timeline in 1985, is it eliminated vacancy control. So prior to that, jurisdictions like Santa Monica and Berkeley had vacancy control, meaning that when Moni moved out of her apartment, her 2-bedroom apartment that she was renting for $1,000, and I moved in, the owner was only entitled to charge me $1,000. That's vacancy control. in the event that Moni moves out of her $1,000 two-bedroom apartment that she rented 15 years ago, and then I move in, and the market rate for that apartment is $3,500, the landlord is able to charge $3,500 when I move in. And that's the amount that becomes controlled. Partially covered properties, also, as Sean mentioned, the Berkeley voters changed our ordinance in November of 2020 to cover new construction, rather to charge a registration fee for new construction, single family homes. Now, Moni talked about the 4 pillars of the ordinance, right? Rent control, which everybody understands best, rent registration, eviction protections, and security deposit interest. Prior to Measure MM, 2 of those pillars, rent control protections, eviction protections and security deposit interest also applied to this cache of properties, the single family homes, condominiums, and new constructions. But we were not able to give any advice or information or services to that community because we didn't charge any registration fee. So in November of 2020, the Berkeley voters adjusted our ordinance to require that landlords of those properties, when they're renting them, are required now to pay a yearly registration fee, and we're able to provide services. That yearly fee is somewhat less than the fully controlled, but it is still, it's $212 per unit. And I want to make clear that when I say single family homes and condominiums, many of your clients are purchasing one for occupancy. That particular fee is not due when the units are not being rented. So in the event that it was a rented single family home, for example, previously, that owner sells it, and the new owners want to move in, and when they do move in, they are not subject to any rental registration fee for the remainder of their occupancy. Okay, now we're going to get into evictions. These are the 10 just causes for eviction. I'm not going to go through each one of them. I don't want to keep you too long. Some of the highlights are non-payment of rent, breach of lease, owner move-in, evictions, and then of course, owner or relative occupancy evictions. So the owner in Berkeley is entitled to evict a tenant household, except for in certain circumstances, when it's one up and one down. When a mother or father is going to live there as a principal residence, or a son or daughter is going to live there as a principal residence. And then of course, there's this sort of strange one where, or the spouse is going to. Most owners own things as joint tenants when they own. But there are situations in which somebody might own it, but their spouse might not. The spouse is similarly entitled to occupancy for this eviction. We don't get this nearly as much as we used to, particularly during the foreclosure crisis. There was a big campaign among realtors called Casper Keys. And essentially what happened was that at some time, at the moment that the bank foreclosed on a property, a representative would come around and generally offer very small sums for people to move out in order to get their keys. But the upshot of this is that the sale of a property is not a good cause to evict. So in the event that your clients are buying a triplex and all three of the units are rented, those tenancies remain, and the new purchaser, the new owner, steps in the shoes of the old purchaser, and all of the terms and conditions of the the established tenancy remain and go forward. So any amount of rent that they're paying should remain the same, assuming that the landlord has raised it to the maximum. Any amenities associated with it, parking, storage, the use of the garden, or anything like that, all remain as they were with the previous landlord. We get frequent calls from the realtor community regarding owner move-in evictions. So, I already went over sort of the who qualifies, and again, that owner, occupant must be a 50% owner. Frequently you will see, particularly family situations, where that might not be the case. 3 siblings inherit the property, after the passing of the parents. None of those siblings would qualify for an owner move-in eviction because they would all be 33%. So you have that threshold question of being at least a 50% owner must be satisfied before you can consider any of this. I have seen owners, particularly when they have children who go to Cal, transfer property ownership into their or when they have relatives who are going to Cal, transfer ownership so that they qualify as 50% owners. Not suggesting to do that, I've just seen. The owner move-in and Ellis Act, which we're going to discuss in the next slide, come with fairly significant relocation requirements. Each year this goes up by the Consumer Price Index. Currently and this is for tenant households, not per person. Currently for tenant households, the standard relocation assistance is $19,126. And the additional relocation assistance is $6,375. And that's for 5 different categories. So tenants who have been there for a very long time, I think before '99, senior tenants, disabled tenants, tenants with that qualify as low income, and tenants with school-age children, all get that extra piece. Now, let's say that you have a tenant household where you have somebody who qualifies as both senior and disabled. You only get that bump once. So the maximum that a tenant household would be able to receive under this relocation assistance is $19,126 plus $6,375. And that's true if it's a 1-person tenant household or if it's an 8-person tenant household. Within 3 days of filing any notices to the tenant or any lawsuits, you have to also file notices with our office. And you've got to include the name and relationship of any other person who's intended to be the occupant, if that's the person who is actually performing the eviction. You can't evict families during the school year. So anytime you evict a tenant family who's been there for longer than a year, then you have to evict during summer months. That's published by the BUSD. That particular protection was incorporated about 6 years ago.
Or not at fault.
Apologies. Yes. Thank you.
You know,
This would be an owner move-in eviction. You're not able to.
Yeah, just to be clear, that's
Yeah.
the owner move-in, which is considered a not at fault, meaning the tenant is not at fault. But of course, if someone doesn't pay rent or you're having that issue, I just want to clarify.
That's an important clarification. Thank you. I was a little reckless when I was talking. But Krista is always there to check my recklessness. Ellis Act eviction is the other big eviction, the no fault eviction. These are evictions where the tenant household has done nothing wrong, but the landlord wants to take back the unit. For owner occupancy, it is for obviously they want to live in there, or the family's going to live in there. Ellis Act eviction is the type of eviction where you're basically just removing all of the units on the property from the rental market. What does that mean? That means you can't rent those units for a while. And if you do, there are penalties. And these are not Berkeley Rent Board penalties. The Ellis Act eviction is a state law. It's in the government code of California. And so the protections associated with this are not Berkeley protections. They are state of California protections. I'm not going to go over these too much. Just know that when you're advising clients who are interested in Ellis Act evictions, the most important thing that they understand is how that affects their ability to rent the property in the future. You got 2 more slides with me, and then I'm gonna pass you back to me. Those eviction, those relocation amounts, those are the same or standard for the owner move-in eviction, which is actually a part of the rent ordinance, and the Ellis Act implementation ordinance is actually the council adopted ordinance that we administer, but they about 10 years ago, they synced up the amounts that are owed, so to the tenant household, it doesn't really make a difference whether you're being evicted for owner move-in or Ellis, you get the same amount. Those amounts that I mentioned on the previous slide must be deposited with our office within 10 days. We are essentially the escrow agent for those, and then we will pass them along to the tenant households either within a certain time period or when we ask, depending on the eviction. That shouldn't concern you. What should concern you is that the money is not paid directly to the tenants. Moni's going to talk a little later about tenant buyouts, which is paid directly to the tenants. But these particular amounts associated with these 2 kinds of evictions are paid to us, and then we forward those to that household. So in the past, when there was a tenant who would claim disability or something like that, the owner said, "I'm sure you're not disabled. I don't believe you." You have to go to court in order to have the court decide whether or not somebody qualified for that assistance. Now the Berkeley Rent Board is able to decide those disputes. They are very infrequent, but they do happen. And we would be able to hold a full evidentiary hearing in which a landlord could present their testimony and evidence showing that somebody does not qualify for one of those 5 escalators. And the tenant, of course, or tenant household rather, would have an equal opportunity to present evidence that they all. I'm going to ask you the money, and then I'll take it on from there.
Thank you, Matt. So this is a really popular question we get a lot at the rent board. So the tenant buyout is an ordinance the city council passed because there were so many buyouts happening. I think they just decided to create some order to the system. If I want to buy out a tenant, I have to do a few things. First, I have to give you a disclosure statement. It says 4 things on it. 1, you have the right to change your mind. I have one client who changed her mind on the 29th day because she realized that she was exempt from being owner move-in evicted because she was in a 10-unit property and she was over 60 and she lived there at least 5 years. If an owner has 5 or more units in the city of Berkeley, and the tenant's been there at least 5 years or more, your longer-term tenants are safe from being owner move-in evicted. And I'm not going to go into all the details, but just know these categories sometimes have exceptions and people can be exempt from being evicted on owner move-in. On that disclosure statement, this is city law. My board's just enforcing it with paperwork. We generally get the information, so we'll send letters to the tenants and we let the landlord know what your rights are. The second thing is, not only can you change your mind up to before 30 days, you can just say no, thank you. And the third is, I'm going to counsel with the rent board. You have the right to that, consult the rent board and talk to council, legal advice. We don't, just to clarify, rent board housing counselors do not provide legal advice. As Karen, I'd like your disclaimer at the beginning. We refer people to legal organizations that can give legal advice, both for landlords. We sent them a lot to the BPOA for referrals, as well as other organizations, but not individual lawyers. And we send tenants to a couple of legal organizations. Listen, the buyout is very, very, very active these days because there's a lot of buying and selling and all kinds of things, as you probably know, maybe your market's picking up. But I see them in our office anyway, coming through quite a bit. So they have these protections when offered, and if the tenant says no, thank you, you want to be careful not to push on it. There's also something called the Tenant Protection Ordinance, which is a city council passed anti-harassment law. And if it's violated, you could be liable to pay the attorney's fees for the tenant's lawyers, although the tenants aren't paying it, but it's $500 an hour. Landlords have told me their lawyers are charging them $600 an hour, whatever the hourly rate might be. So you don't want to pay your lawyer and their lawyer, so anti-harassment, none of you would have harassment either with your clients, but they just want to be careful about seeing like they're pushing that buyout when the tenant has said no. So they can agree just to stay. They don't want to move, they don't want to give up the premises, and at which point, this is where we get a lot of conversation about your alternatives. So I talked to a lot of buyers of property, realtors. Oh, and please, when people call to ask, do we have a golden duplex or do we not? And I ask you, when is your offer due? Because they're like this afternoon. I'm like, no, please call us at least a few days in advance so we could do the research and get a little more information. I could do a quick glossy read over and see if it might qualify for the 1979 tax assessor role, and it showed the homeowner's exemption and the person lived there, did live there, because it also shows their address. There's exceptions and all. Anyway, make sure, because what people are negotiating in this analysis is, I'm gonna offer a buyout because of this. If I do an owner move-in, just know this, tenant has the right to come back at any time. I call it the eternal right of return, but they can come back 5 years, 10 years. So let's say I buy the property and I want to move in. I moved into unit 3. There's 2 other units. The unit that I moved out of, the owner unit, the tenant has to be told when it becomes available and they come back at the rent control rent. So just FYI, I know that, and also know, that's why some people say, can we just do a buyout? And then the negotiations begin. It's whatever the people decide between the 2 parties. We have some mediation services at the Rent Board, and we have had staff attorneys facilitate mediation, murder settlement, and buyouts in that way. So it's written and signed off, etc. We also have legal organizations doing some of those, but just know that the owner move-in has ties to it, which are baked into our system. It'll pop up. And I had a client, a landlord, who she said her daughter was going to move in. Daughter did not move in. House student couple moved in. And the rent board sends a letter to that address a few years that says what the rent control rent is, which was like $1,900, $2,000. It was a couple years ago. They were being charged $3,000 something a month. And so not only do I, the displaced tenant who had the owner movement eviction, have to move out. I mean, not have, I moved out. But if I don't move in, I've moved back to Seattle, I'm happy I'm not coming back. If you move in and you take my unit, you get the rent that I had. So all that being said, people want to sometimes negotiate with these things in mind as far as the buyout versus the move-in. So just know that when we talk about one, we usually talk about the other. And in terms of the process, when realtors are calling us and buyers are calling us, like, what are my options? I'm like, well, you have a new tenant. Or you have a buyout. Or you have the eviction process to go through. So you inherit the tenant, or you have agreed to negotiate a buyout, or you do the formal eviction process for own living. And so the buyout, the next slide, thank you so much. Those are the right things you have to show on the disclosure statement. We have a copy in our packet. It's also on our website. Next slide, please. In the agreement, the tenant buyout has to have that language in 14-point type, and it has to say those exact words. So I'm just type that in. You have to give a copy to the tenant. And then you have to file a copy with the rent board between day 31 and day 60. And you have to attach the mandatory buyout agreement disclosure form and keep it yourself for at least 5 years. And the last thing I'll say before sending it back to Matt Brown to talk about your favorite topic, owners. Some people like ADUs, that's coming up. This buyout chart that we have I send it out, all the housing counselors will do this upon your request. I was gonna bring one. I didn't bring it, but there's a chart from 8 years ago where buyouts were like $5,000, largely because they were tied to the amount that maximum you will get is the owner move-in amount. So if I'm an owner and I buy a property and I'm gonna take your unit, and I'm like, I bought it, I'm sorry, but I moved up here, I'm happy to be here, love Berkeley. Okay. So now that, you're moving out, I'm going to then have all these other things that are gonna attach, but I just wanna make sure that people know, like, literally, they're all over the place, the amounts. There are 5,000, there's 10,000, there's 20,000, there's 30,000, there's 80,000, there's 100,000. So if you look at our chart, and people will ask us the question, so what's the formula? And I say, there is none, but it's what people need to move and to survive financially. Usually they're trying to key that in, like, my rent's gonna go up $800 more a month. Can I afford to stay here? I wanna factor that in. Or they need a mover. They still ask for practical things. They need people that have to move. They need more time. Whatever those terms are, those get typed up. The attorneys that are doing them or the groups that are helping them do these, they file them with us. And you can't see it because all that information is, private, but you will see that street name, the length of time the tenant might have been there, and the amount on this chart. So if anyone wants to see the tenant buyout chart, call a housing counselor, we're happy to give it to you.
This is the other topic. This is the other topic that generates a lot of interest. As many of you know, there's been recent changes, particularly in state law, that gives by right construction of ADUs on properties when certain conditions are met. For the most part, almost every single ADU in Berkeley is not almost every, but the vast majority of ADUs in Berkeley are going to qualify as new construction. Anything that was built after 1980. That qualify under the definition of ADU from the planning department, which is the definition that we use. And again, if it is an ADU that was built prior to 1980, it would be fully controlled. If it is, if it's a pre-1980 unit, but the big but there is that it still might qualify for a golden duplex exemption during times when the landlord lives there, if the landlord otherwise occupied that. If a landlord occupied a unit in 79. Most of the ADUs that we find are exempt under this second particular box here with it, which is the ADU exemption. So just like with the owner move-in, rather the golden duplex exemption, which has a little bit more of a specific requirement being the 1979 occupancy by a property. Remember, it doesn't have to be the same property owner who occupied it, it's just any property of 50%. The ADU exemption doesn't make a difference when the other unit is owner occupied. It just makes a difference when the ADU was constructed and when it was rented. And of course, the other big thing on the horizon, I don't know if Kieran or Christo were talking about this, but the new proposal that's making its way through council right now to subdivide properties and be able to sell ADUs separately as condominiums. Currently, as you all know, when you have a principal residence and an auxiliary unit on the property, either connected to it below as part of the back of the home or a backyard cottage or whatever, those two residences are not able to be sold separately. They are not separately alienable. They must be sold as one entire parcel, and all buildings travel with that one. Well, there is legislation making its way through council, which I'm sure many of you are tracking, that would allow property owners to subdivide those properties and create two separate parcels, one being principal residence and the other being the auxiliary ADU. So as we teased at the outset, the voters passed an initiative in November of last year that significantly changes our ordinance. Landlords now, at the inception of all tenancies, have to provide a notice of property rights, of tenant rights rather, to let tenants know, for example, whether they are partially covered, exempt, or fully covered. Now, I know that you're gonna try and correct me the exempt piece, and you can. We maintain that that property owners should, whenever they sign, and this is for new tenancies. So if a tenancy was established 6 years ago, you don't have to double back and say, hey, your tenancy that was established in 2019 is fully covered. I just wanted to know. This is for any tenancy that was established post November of 2024. Property owners have a duty now to let tenants know that their unit falls under one of these three categories. I'll let Krista correct me on my own time. So another thing, that we have seen is that oftentimes property owners, for trying to do capital improvements, will submit a pre-application to see what they might be eligible for. That particular section of the ordinance was eliminated. So now, in the event that owners do major capital improvements, put a new roof on, significantly change the plumbing systems, whatever they do on the property, and they might otherwise be able to pass some of those costs on to tenant households in the property. They would have to wait until the project is completed and then submit for hearing whatever they contend that their capital improvement increase would be. So you can't get a preview of that now. The annual general adjustments are now capped at 5%. They used to be at 7%. That may sound bigger than it is. In my almost 22 years of being here, 4.4% was an outlier, meaning that was very much the highest. I've never seen it above 3% in any other year. So that cap is important during times of hyperinflation, but it would be hard for me to see that we would ever get there. But nevertheless, rents can only be raised by a maximum of 5% per year. When the CPI supports that information. The big thing that Measure BB did was it brought a number of government subsidized units, Section 8 units. So a number of private landlords rent to Section 8 voucher certificate elevators. And those units previously were subject to eviction protections and to security deposit interest rules, but were not subject to either registration or rent control. Now, in units that were otherwise qualified, those Section 8 tenancies would be fully covered by the ordinance, meaning that they would have both rent control and registration requirements. So anytime you're selling homes now, or rather properties that have Section 8 tenancies, it's important to let the landlords know that they would not only be regulated by the Berkeley Housing Authority, but potentially be regulated by the board as well. It used to be that you could evict for non-payment of rent of any amount owed. Now you're only able to evict for non-payment of rent when there is at least 1 month of fair market rent owed. And we maintain records on that. And fair market rent would be the from HUD stats for the area. So in the event that you have a in the event that you have a unit that pays below market rent, it might take 2 months, for example, to rise to the level of something where you would be able to evict for non-payment of rent. There was also, you know, we live in a college town, a lot of landlords rent somewhat seasonally, and a lot of landlords are very interested in security associated with a full year's lease. And so the way that it used to work was that a landlord would be able to initiate an eviction action against a tenant household if they fail to sign a substantially identical lease upon expiration of the last one. In very clear terms, what does that mean? I rent to a household, their start date is August 1st, their end date is July 31st. At the end of their lease, in May or June, I come to them with a new lease and I say, I'm requiring you to re-up for another year, from August 1st till next July 31st. And if you don't do that, I'm able to evict you. That is no longer a good cause for, a just cause for eviction. That is, now all tenancies become periodic at their expiration, unless a landlord has another one of those 10 just causes to evict. I mean, we've given you so much information. We don't expect you guys to be experts at this. We expect hopefully that some of this is going to tease some of the issues that you look at when you're in conversations with your clientele, and to contact us. And so, you know, part of the reason why we reach out so heavily to the the realtors in the area is to really try to encourage you to pick up the phone and call Moni. Moni's she's gonna let you know what the status is of the property. She's gonna let you know whether or not there are registration fees that are due and owing that your clients might step into. You don't want to step into debt. That's the last thing you want to do. She's gonna let you know if there are exemptions which apply, or if there are some other things on the property going on. Our database is vast. We've been collecting data now on these units for more than 45 years. So we have a lot of information, and we're able to really guide folks in these situations. It's important, you know, that before you get into contract, that your clients understand where they fit in to these categories, and how that might affect their ownership of the property. Tenant estoppels are not required. A lot of times we have realtors who are very insistent that tenant households sign estoppels, while tenants are perfectly capable of deciding whether they are going to decide them. They are not required to sign.
In most leases, on occasion, one so. And then it's a material term of the lease, a violation of the material term of the lease is grounds to be evicted, and therefore you might be able to push the stop a bit. Just FYI.
Right, and then the other important piece to that is that the existing lease survives. And there's no requirement that a tenant household sign a new lease.
That's super important, because a lot of new buyers say you have to sign this new lease, and I tell them, no, it's not true. You have, regulation 1313 says that a owner cannot make unilateral changes to the lease. So otherwise, the irony is, anything that you do in violation of a lease, you can be evicted for. So that's one reason why the board years ago passed that regulation. So you adopt and inherit the lease that they have.
So these are not, this slide are not pieces of the rent ordinance or of our program, but we always encourage folks to be aware of these things, because these are certainly programs within the city that affect tenancies and landlord-tenant relationships. So in the event that a tenant household experiences problems with lack of heat during winter, or with rain leaking or whatever, they might call a housing inspector, and that's the rental housing safety program. Rental housing safety program also has certain requirements that landlords self-certify on a periodic basis. it's important to just understand those things. And, you know, while we have information about that, we are not housing inspectors, and we have no authority to issue any kind of code violations for that. But these are things that are important. Business license, if you own, if you rent to, I think it's more than 4 units. Yeah, if you own more than 4 rental units, you're gonna owe another fee to the city. Again, not a part of us. There are certain fire inspection, periodic fire inspections that happen. I'm gonna I see, Krista clamoring to start talking, so I'm gonna go ahead and, this is a good, oh, I forgot to do that. I apologize.
Time check, are we at 2 o'clock or
We're-
1:45? I thought we go to.
We need to give Krista some time.
No, I'm saying.
We're till 2,
2, right?
Yeah.
Okay.
as long as everybody's okay to sit and.
So I'm gonna let Krista talk for a bit. Krista's going to talk for a bit. And we find that, you know, the question and answer part of these is often, you know, really important for people who have been holding in things that they want clarification on. So we'll stick around for as long as you wish for that. Thanks, Matt.
Yeah, thanks, Matt. I'm just gonna fill in on some of the stuff that they said. I'm not gonna do a lengthy presentation to you, but in fact, I don't even have slides. But so I'm Krista Branson. I'm the executive director of the Berkeley Property Owners Association. We've been in existence since the inception of the Berkeley Rent Stabilization Ordinance in 1980, and we started out as volunteers, just rental property owners. Actually, it was the Black Property Owners Association before it became the Berkeley Property Owners Association. But we really are your partner in selling and buying of real estate in Berkeley. And right now I say real estate as opposed to investment income properties, because the reality is most rental housing in Berkeley is owned by small owners. Some people refer to that as mom and pop landlords or mom and pop owners. Our membership makes up 23% of the actual market in terms of units of ownership, which is a pretty big amount for a trade association. But 75% of our members own fewer than 3 units, meaning it's either a single family home rental or it's that duplex situation. So what we're really here to do, and I just asked, I love that our holiday party is on. A question about our holiday party is like the first and front thing, but really what we are, education and resources, both for your industry and for the actual owner, so your client, either on the buying or selling aspect. So the Rent Board and I, Matt and I rib each other because we've been doing this together for a decade. So I've been head of the organization for 10 years. But the reality is that we both work, and Moni and I are very much in tune with the fact that we believe education and information is key in this process. Because getting hit with something you don't realize, like the property she was talking about where the owner was like, oh, you know, I didn't realize I was under rent control in my 5-unit building. I mean, that's a huge thing, right? Rent control affects the cash flow of that investment income property. And so education and knowledge and knowing ahead of time before purchasing, and also knowing ahead of time before selling, that's a really big aspect too, is important. So the things we can help with, and this, you know, the Rent Board definitely does help landlords. There is kind of that idea that they don't, but they do. But they also refer out to us a lot because it's a lot of work. This industry takes a lot of work. And so if you are doing that quick close or offer and you don't have the information you need on that golden duplex, we actually can help you get an idea as to whether that is possibly a golden duplex eligible property, because both the Rent Board and us have copies of the property tax records of 1979. And that is one of the first key checks to see that the Rent Board uses, that we use, to let you know if that's a golden duplex eligible, what I call eligible parcel. But the challenge is there's so many nuances to all these things. I mean, they got into quite a bit, but there's even further nuances, even in the ADU world, in terms of what is partially covered, what is fully covered. And that's what we're really here to help kind of sort out for you. Matt is great. Matt's a lawyer, and Matt is great at giving you facts. And then a lot of people will come to me and kind of get like, hey, can you help explain that further in layman's terms? And more importantly, can you help explain that to my prospective buyer? or to my seller. And so we have a lot of education resources. We have them both for you and for your clients. I wanted to make note, one of the things that when they were talking about these different units, especially the ADUs, is it's important to know that the rent board and the rent regulation does not look to building department legal or conforming units. So for them, it doesn't matter if the unit is legal or non-conforming or illegal or non-conforming, which, as Matt was talking about earlier, a lot of stuff that was built after the World War, and then also in the 80s, we had an influx of these basement units being converted. A lot of those were converted without any sort of building permit. That is a separate department. Building department is separate from the rent board. And so it's important to know that even though those might not be legally permitted units, they can come under the regulations of the rent stabilization ordinance. And so that's a really important piece to know as well. We can also help you on the building department side as well. There's a new, I don't know how many of you have heard of the new beta program, the ADU amnesty program, which is helping to bring forth some of these units that we're all referencing here, to legalize them to an extent, to make them conforming. Right now, it's just for single family home properties that have that second unit, whether it's that converted basement or that granny cottage or converted carriage house in the back, but that's a really important thing to remember. I also want to make sure that you understand that, you know, some of the stuff we're talking about here, the legality of things does put sort of like deed restrictions on the property. So Matt mentioned Ellis Act, that's a state law. It does put a deed restriction on the property. I almost say that some of the owner move-in stuff also has a deed restriction in the sense of what Moni was talking about, that, you know, if you do an owner move-in and then that owner leaves at any time, they have to make a good effort to try to contact the tenant that was displaced through that owner move-in and offer them the unit for rent again. And so for us, we sort of consider that a deed restriction as well. So it's very important for your clients to understand what restrictions might be there. And so part of it is based on explaining how the law works, which is part of what our organization does. And the other is checking in with the rent board, because what the rent board has is they have specifics of properties, as Matt states. They have a history of property. What we can help you with is we can help interpret some of that paperwork, or like, what is the rent ceiling? What does this mean as it relates to my unit? But they're the ones who are going to give you the specifics about the property. So we're really here to help you with compliance, which is key. Okay, I cannot tell you how important compliance of that property is. Because if your property, your client's property is not in compliance with the rent stabilization ordinance, there's a lot of things that that owner is not supposed to be doing or can do, like rent increases or even evictions. And so it's really important that you kind of get a sense for your client, help your client get a sense before they sell and before they buy, or before they buy, how compliant is this property? Because that's going to make a big difference for, they can close their ears, for cash flow purposes, right? For maximizing the cash flow of the property burning right now. But there are ways to maximize and within the law. I mean, the law is there, but the law has aspects of it that are fair return and on market, you know, fair return of the investment. And so sometimes people aren't maximizing that as an owner, and maybe a new owner does want to maximize that within reason of the law. We're here to help with that. I also want to make sure that you understand that there's a lot of nuances on ADUs. So they were talking about it kind of generally because we don't have a lot of time to get into the nuances, but I find that ADUs are very nuanced. It depends. Is it that granny unit that was built in the last few years in the backyard? Or is it that converted basement or that converted attic? Because those do matter, and timing, when it was built, did it receive a certificate of occupancy, which is, you know, the Costa-Hawkins exemption key piece. Those things all matter. So it's not as simple as, oh, this is an owner occupied 2-unit property, therefore, and an owner currently lives there and is renting out the other unit. It's an automatic exemption from the rent stabilization ordinance. it is nuanced, and that's really where we can help pull you guys through if you need help, or even bring your clients to us. So those are just the key pieces I'm gonna touch on, because I know people always have a lot of questions, and we're happy, any of us are happy to help with that. I wanna let you know that we do have a realtor membership. It's a newer thing. It's $399 a year. I have flyers here with a coupon for $50 off. We're really here to help you with your clients. I know for you guys, you don't provide legal advice on these things either. And these guys, as they state, they don't provide legal advice. We provide guidance from a legal perspective. We also have direct ins to tenant attorney, or excuse me, we do have direct ins to tenant attorneys. We try not to talk to them sometimes. Landlord attorneys, we can help with that. But you know, being connected with us helps you really with your clients, and that's what we're here to do for you. So if you have any questions, we're happy to help. I think that's it on my side. Did you guys have anything you wanted to add before we open it up for questions?
Nope, let's open up the floor. Got 30 minutes left. You can ask questions. Well, it's one thing you said, nurses. So, yeah, just to call us, call the Rent Board. Oh, legal advice. We will tell you what the law says, and we will consult with our staff attorneys. But we can't give you legal advice as a client to an attorney-client relationship. So people get kind of upset and like, oh, your agency, you should know all this and you should get this legal. And like, no, we can't legally give you legal advice. It's just not permitted.
Yeah, I think that you guys do best with explaining and saying, hey, this is what the law is, and then you can kind of come to someone like us or an attorney to say, okay, now that I have this information about this property, what are my clients' options, right? We talk a lot about capture keys, buyouts. You know, you're able to do those, and that is a lot of way that people will clear properties, then you don't have that deed restriction. And that's not something they're gonna advise on at all, other than the chart they can provide you. You can come to us and you can ask me, like, what do I believe the average buyout is and how does that get computed? And also, just as an aside, I've been doing this for a long time. I also have a consulting practice for all of Alameda and Contra Costa County. So if you have clients in other areas and you're also kind of questioning the law in Oakland or the law in Walnut Creek or whatever, I'm happy to help with that as well.
And I also wanted to make sure everybody receives the packet of handouts, and then Karen will send to you the slides. But who wants to ask the first question? Are you gonna be the right guy?
I can be the mic guy.
All right.
I've been itching to do something for this.
Do you guys
All right, anybody
have
have questions? No? Let me check online. Oh, we do have a question. All right. One of our clients has a triplex with one renter being there since 1995. Thus, the rents are $1,300 a month instead of market at $3,300 to $4,500. What are any methods you know of to get Berkeley and to Oakland to understand that rent control makes it unfeasible to maintain the property?
Clarification, they said there's 3 units and only 1 is rented.
Yes.
Why doesn't he rent the other 2?
Oh, no, I think it's all of them are being rented. It's just that one renter has been there since 1995.
Yeah, so 1/3 of it is under market.
Okay, so just an FYI, and it's not perfect, of course, but a large number of the units are constantly turning over in our college town to market. I'll have a tenant tell me, what do you mean the rent's $2,300 a month? That's the rent ceiling in our database. And the landlord, tell your clients, please update their tenancy information, because it says $2,300, but the actual rent is being charged at $4,500. I see a lot of rents at like $3,000, $4,000, $5,000, $6,000, $7,000 and 5, 6, 7 tenants in a 2-bedroom, and they have a double, and a triple, or whatever. Market rate rent, it can be charged. There's no limit. We don't regulate the initial rent. So I just want to suggest that they know that the other 2 units, assuming they have tenants that are turning over, and when they move in, then it's regulated thereafter. But I think there are very few long-term tenant buildings that are like 100% before the 90s. There are a few.
Yeah.
Right?
Yeah,
Yeah.
it's getting smaller and smaller, but to see a building like that, or a property, I won't say a building, but it's a triplex with 1/3 of it under market isn't too uncommon. But yes, and this is where, I have the ability to say that rent control, I mean, this is the challenge of rent control, right? And so we are in a town though that does have a high turnover rate, more so than places possibly like, Oakland or Alameda, for instance. But that might be one where that particular realtor might want to contact us and talk a little bit more about what other ways they might be able to maximize that. I will say there is an option, and Moni deals with this all the time. It's not like she's gonna tell you, hey, you don't do a buyout, that's not fair. She'll just tell you, hey, this is what the buyout ordinance is. And I'll tell your client, hey, you might want to consider a buyout on that particular unit. Maybe the tenant is ready to move on. Maybe they will take a sum of money to vacate, or maybe not. Now, some people don't believe in that. They think they should stay in rent stabilized unit as long as they want. And that's fine. We can have a differing opinions there. But yes, it's just to finish to the end to his question or her question is, yes, we constantly try to advocate that to elected officials, and that's what Karen and I do together jointly. And it is challenging, but I do want to say this rent board does, and the commissioners, Mizell is left, but the commissioners do have some level of respect, which I really appreciate, for the smaller owner. When that tenant lives on site, this is something I say all the time, when that tenant lives on site with the owner, it is a very different relationship. It's like, I say it's like a marriage. And if somebody pisses you off, ooh, you don't want to see them at the laundry room for the next 4 weeks. It becomes different. And so that's what we really try to advocate for. Karen and I do a lot of advocating for that, to be treated differently. And the rent board does, and the staff has a lot of respect for that too, and really tries to help the smaller owner along. But that's also the client that has the least amount of knowledge. And they're the ones that get surprised in the purchase or the sale. So that's why it's so important to impart. So thanks for letting me go on about that, but
No
I'll
problem.
make sure we answer their
I think
question.
you know this member, she probably will call.
Yeah, that was, great.
Any other questions, guys? And it's a lot of information, but if you have anything that you want to ask you guys right now, this is the time. All right.
And just so everyone knows too, that a tenant survey was done, and a large number of tenants in Berkeley are aging. We have like one of the fastest aging populations. And a lot of them are on fixed income, and the only way that they've survived in Berkeley is because they're rent stabilized rent. So to the property owners I know who like to ensure families are taken care of and elders, it works in a good way, particularly if you have other units that are making more money rent. So just FYI, the facts are a lot of people are just low income seniors, and there aren't any affordable housing buildings, and the few that there are, there's waiting lists of literally 5 or 6 years, or thousands of people that have applied for 5 or 6 below market rate units or affordable units. So it's the reality of the market that makes it really hard for people to afford to live in Berkeley, and people are shaking their head. They agree. Look, here's a question. I just generated a question. Let me not yet.
Okay, so I have a question from somebody about, so I'm a real estate agent, so I have a lot of people who come into town and I advise them, rent for a year, figure out which neighborhoods you like the best, and then we'll buy a house, right? Like, let's not rush into this if you don't have stability here. Let's sort that out first. So I'm getting feedback from people that they feel like the tenant screening is so intense, and they're really frustrated with it. And I've had people telling me, like, these people are like checking under my fingernails. Like, this is.
Times the rent, isn't it 3 times the rent, income 3 times the rent?
Yeah, I mean, there's industry best practices, so 700 credit score minimum, and then, yeah, gross income 3 times the rent. But yes, it's hard, and I will say, I mean, these guys have heard me say publicly that we believe strongly that the increased rent regulations and the over-regulation of this industry does cause that kind of thing. I mean, when you think about it, if your tenant has eviction protections, then it can be harder to get someone out. And so if you're thinking about that, you're gonna, as an owner or as a person vetting a tenant, you're gonna look at that really closely and say, okay, I gotta be really sure that this person is gonna pay rent. Because even when they don't pay rent, it's a process. They have a right to a legal process to determine whether it's true they're not paying rent, what they were supposed to be paying rent, et cetera, et cetera. I mean, I was just in eviction court this morning. I just spent the morning in eviction court. A lot of 90% of eviction cases are non-payment of rent, but it's still a process. So that does turn into some really long and difficult vetting processes. I wish it weren't true, but that is just the reality. So I understand. But there's also a lot of small owners who don't even care about that stuff to this day.
Yeah, they just
You
like
know,
building.
They go on a feeling. And I mean, I have people who's like, oh yeah, 30 years I've been going on a feeling and it's been fine. That's our ecosystem. So yeah, they just gotta find that small, yeah, until something happens. So they gotta find that smaller owner would be my recommendation for any client that has that issue, as opposed to the larger property management companies.
They have questions in the back.
Is there another question?
Yeah, one of the uses. One of the effects of rent control is that sometimes tenants will have very, very low rent. And then they have a life change and don't want to live there anymore. And then they've got this asset of a below market unit that they don't want to live in, but they also don't want to give up, and they sublease it without the owner knowing. Now, I'm wondering if there's been any sort of, is that something that the rent board would hear, or? would
Yes,
that
we
be-
hear it all the time. We file a petition. It's called an IRD. And
What?
rent determination petition. So if there's evidence that the tenant who's the original is no longer living there,
Yeah,
it could be challenged in a hearing and the rent can go up to market for whoever else is there now. So just call the rent board. I think Matt has something too. Or did you ask? Oh, never mind. Did you have a follow-up?
that would be the first step, is to take it to the rent board, not to issue a notice.
You could also do both.
What would the vote be?
Yeah, simultaneously, if that's the case, we recommend that, the property owner issue a rent increase notice on the new occupant. And then they can file this kind of petition that Moni is talking about, which is called an initial rent determination, IRD. And the claim would be that the person who has the right, the original occupant, to that, lower rent ceiling, is no longer permanently residing. That's the term that's used, no longer permanently residing in the unit. And if they prevail in that, then the rent can go to market, and I've seen a number of landlords prevail.
Is that a 90-day?
90-day notice for over 10% rent increases, 90-day notice under civil code 827.
Yeah, that's the California Civil Code in terms of rent increases, 30-day versus 90-day, but we can talk, that's where like Matt gives you the good information about what's possible from the rent board, and then we can help you kind of suss that out a little bit more. The other thing to keep in mind is that it's actually illegal for a master tenant or an original tenant who's vacated to possibly be charging more for that unit, which sometimes people do. And that is a tenant issue, but it becomes an issue for the owner who's not getting a market rent. They're getting the lower rent, but their tenant might be making money off of it by re-renting. But there's definitely options, as Matt and Oni just mentioned, in terms of that. And we have a couple consultants that help to file petitions with the rent board. You don't have to have an attorney for that. You could do, an owner can do it themselves. But if it's a little too complicated, they can get a consultant like myself or other consultant to go through the process to show that, hey, that original tenant is no longer occupying that property and that unit as their primary residence. And that's important because that's what they have to do in order to enjoy the benefits of rent control, that stabilized rent. Matt, did you want to correct me on any of that?
No.
That's the,
Thanks.
Well, that overcharged tenant can file a
So you
claim.
do a small
At the
claims
rent board.
lawsuit, or at the rent board, right?
Yeah.
oh, against the original tenant?
For overcharging, because they're performing an illegal activity as well. They as well cannot charge more than the allowable amount at the rent ceiling,
So
just
they,
like an owner can't.
they owe a reimbursement to their overcharged subtenants. And I've seen it happen a number of times. And there are a couple people seem like total, I don't know, characters where they're running an operation and they have a whole group of tenants that come in and they go out, they come back in, and they're charging them hundreds of dollars or thousands more. They had to repay those tenants that they overcharged. So there are systems built to make sure it's fair for everyone and not allowing those not nonsense things happening. So there are ways, and people don't think there are, but there are. So you learn something today and tell your friends. Tell your friends to call the rent board.
Just before we leave, I know that there's a fairly small group here, so this is also for the folks online. Before COVID, Moni and I went around to a lot of the Realtor offices, particularly during the weekly huddles. And obviously, we gave you a ton of information today. We are able to tailor a presentation to any sort of specific topic that you might have. So if you are interested in having us come out to your offices, during one of those weekly huddles, we'd be happy to come out. Just contact Moni. And she'll, and we can set something up. I would say we did it 3 to 4 times a year. And then as well as this particular presentation, there wasn't an online option back then, so it was a much more crowded room. But we are happy to, to reinitiate, those visits, if people have, any interest in.
We also do the same, sorry, we do the same, I just did a Compass Realty on Delaware yesterday at their weekly sales meeting, so I have a refined one as well that covers some of the things they do, or you can have the 2 of us together, whichever you prefer.
One last, maybe technical question for you. Okay. Will a single family parcel for residents, owner occupied in 1979, which subsequently receives or has built on it a second unit, whether it be an ADU or in-law, with a certificate of occupancy, be categorized as a golden duplex?
It's a tricky question.
If it is built separate from the principal unit, the answer to that would be yes. If it's a subdivision within the principal unit, the answer is maybe. So, I mean, we have to look at that, but certainly, the most common form of an addition would be that backyard cottage. As Krista, I think, astutely pointed out, the board makes no determination regarding legality. It's just whether or not it is rented and when it was built. And in the event that there are no permits, it doesn't really matter when it was built. So if it qualifies as a fully permitted ADU and it's built in the backyard, then it would always qualify for an exemption rather a full exemption when the other unit is owned.
But will the single family home also be exempt from rent control and just cause?
No.
Living in it.
If the owner is living in the fully permitted
It has to be,
ADU.
that particular exemption that I'm describing is contingent on owner occupancy.
In either the ADU or the single
Right.
family home?
In the event that both units are rented, then there would be partial coverage in both.
Because of new construction. Yeah. But then, yeah.
Someone said, "Oh Lord," that's exactly it, is that, and this is what our 2 organizations deal with every day. Every property has some nuance to it that needs to be reviewed either by us and or the rent board, but always involve the rent board because they have the property file. It's really important to know. So if you've got that, "Oh Lord," going in your head, call them, call us, get it all straightened out, because there are a lot of little nuances. They have a good chart, and we have a chart as well on our website that's open to anyone. If you take my card, I'll email it to you. They have a chart that says what properties are covered and what aren't, and ours extends all the way out to these other agencies. Do you have to have a business license? And pay business license tax, which is a tax on your gross rental income, rental housing safety program inspection, which is basically for all and every unit of rental, all those other aspects. So if you want a quick chart on that, that helps guide you, and then you can call us for really specific information or call them. That's the best way to go.
Owners of 5 or more units have to register for the business license, sorry. Thinking instead.
No,
Like,
there's a
what?
2-tiered, business license
Right.
tax. And actually it's 3 units and above. So it's if your property is 3 units or more, you have to register. If you own 5 or more units in the city of Berkeley, then you have to pay a stepped up higher tiered tax.
I read the wrong paragraph.
That's okay, yeah. You guys are not the business tax department, so don't worry. But I do want to mention that I've actually gotten a few calls recently because the business license tax is due no later than every March 1st. The penalties are similar to the penalties here. If you don't pay the the tax that you're supposed to pay, just like if you don't pay the registration fee, there's 100% penalty. And I had an owner call me yesterday and he just had 2 units. And he's been renting for 7 years and he never paid, he has 3 units, he never paid the tax. And now he's got all the penalties. And I'm telling you, the business license department is not as nice as these guys are when it comes to, because the executive director, Shauna, has the option and her staff have the option to do what they call ministerial waivers of some of the penalties related to registration fees. They do think about things and take an individual into consideration. The business license tax department's like, no way, we're the IRS, you didn't pay your taxes, you gotta pay your taxes and there's penalties. So I just wanted to remind you of that for your clients.
We do have that attachment here, the other agencies.
Oh, the business, the other agencies.
All right, guys, thank you so much, Chris. For our members.
Oh, can you have, fill out our surveys and give? us
We will,
feedback?
we will distribute the survey either online or here, and then everybody that wants to stick around and we have a few minutes for them to answer some more questions, please do. That is the benefit of showing up in person, people. Thank you so much.
You're shut out.
And I hope you had a great time. Bye.
Thanks.
Actually, yeah. Thank you so much.